All right, folks, buckle up. This one has it all. Self-representation, bond confusion, and a cocaine test debate that could rival a soap opera plot.
Good morning, Assistant Public Defender Lauren Perny on behalf, well, not on behalf of Ms. Brown. We are the attorney of record on this case. When I did meet with Ms. Brown, she informed me she wants to represent herself.
Your name?
Alexis Brown.
All right. Is that correct that you want to represent yourself?
Yes, it is.
So,
Right out the gate, Alexis Brown drops the bomb. She's firing her public defender to represent herself. Risky move. In legal terms, this is like stepping into a UFC fight with no training, no gloves, and thinking you'll win on instinct.
in this matter, Brown, I do have to inform you that the complaint in this case alleges that on or about June 8, 2024, location of 3001 Woodland Hills Drive in Pittsfield, Washtenaw County, State of Michigan, that you did commit the offense of assault and/or assault and battery against a Latasha Browning. Do you understand what you're charged with?
Yes, I do.
That is a misdemeanor punishable by 93 days in jail, $500 fine plus court costs. Do you understand the maximum penalties?
Yes, I do.
There are certain things that are fraught in self-representation in terms of understanding the Michigan court rules and in terms of the court procedure. You would need to understand that if you would like to represent yourself, that you would be held to the same standard as any other attorney.
Mm-hmm.
The court will not be assisting you in any fashion whatsoever. You understand that?
Okay, so the time that I served, don't that counts for the 93 days?
I'm sorry?
The time that I served already, don't that counts for the 93 days?
I don't know how much time you
I served 30 days already.
and if you serve 30 days, it may count. I'm trying to look at what your bond is on this case.
Here comes the first curveball. She's already served 30 days and wants them counted toward her 93-day sentence. This is what's known as credit for time served. Smart question, but watch how the judge handles it.
What do you have a bond?
And then no contact with the victim's loan.
And the monetary amount? 5,000, 10%, then it should count. Yes, ma'am.
And so I have a question. So when I was arrested, I wasn't actually told my rights. So ain't that against the law that you wasn't told your rights when you arrested me? Well, not you, but the officer.
I cannot.
You can't do nothing about it right now?
I
All right, I just want to state that.
I can't answer that.
I just want to state it.
All right.
Okay.
Stated.
It's on record, right?
So
Okay.
what do you want this set for, ma'am?
Your Honor, we have no offer at this time.
Do you want it set for a trial, ma'am?
Sure, I guess. I guess.
You want a jury trial or a non-jury trial?
It doesn't really matter.
Well, you've got to make a decision, ma'am.
If it gotta go to trial, then it gotta go to trial.
Okay. Do you want a jury trial or no trial?
It doesn't matter.
You have to make a decision, ma'am.
It could have a jury. Fine. That's fine with me.
Jury final settlement conference in this matter will be set.
Jury trial or non-jury trial? The judge is practically begging for a straight answer here. This matters a jury might be more sympathetic, but also more unpredictable. And Alexis, she's treating it like picking toppings on a pizza. Whatever works.
17th, 2025 at 9 a.m. Jury selection in this matter, October 20th, 2025 at 8:30. Both of those proceedings are in person. Thank you.
So am I free to go? So why am I not free to go? If she just said she ain't got a bond.
Pardon?
Why am I not free to go? Why do I gotta serve time when I'm not even?
You have a bond on the case, ma'am.
So if I get my money, I can get out. But she just said it was no bond.
Post bond, you can get out.
So I'd rather post bond. So where do I go from here?
You need to post the bond.
Okay, what's the bond? Cause you just asked her the same thing, cause she said
5%.
it's $500.
Yes, ma'am.
Okay, so I'd rather post bond. Where do I go from there?
And you can go post bond.
Okay, thank you.
And here's where the second half of this hearing really shifts. The judge is about to lay out a timeline of drug tests. That's, well, not looking great for the defendant. Let's just say the pattern here is as subtle as a fire alarm.
It's your fault, parenting. Certainly, there were the issues in terms of what she said over community corrections. There are all those things, and you have cocaine showing up in her system. And that was on June 4th that we were here, and she admitted to the violations. And I had revoked her bond at that time. Ultimately, she got out. On the 18th, this is June. I adjourned it to July 16th today, or July 16th, and her bond was continued, and she was to continue her testing. And then ultimately from the 18th, from July 16th, it gets adjourned to today. Starting in mid-June, or the end of June, June 30th, well, I'm gonna start mid-June, June 18th, positive for cocaine. June 30th, positive for cocaine. July 8th, positive for cocaine. July 16th, cocaine does not show up. I'm presuming she's supposed to be on the benzos and opiates, but. And if it had started to head that way, we'd be fine, except that the next week, 5 days out, she's positive for cocaine again.
She says she's not using cocaine. She says that the tests are incorrect. She's gotten the tests since then, and it was negative. She wants the court to know that.
Where?
At community corrections.
She's done a test since when?
7/31, her test was negative.
You're using cocaine. That's what's going on. Boom. No sugarcoating. No dancing around. Judges rarely get this blunt unless they're fed up. And trust me, by this point, patience is running on fumes.
Today.
And she said she tested today.
Right. But the test before then was not.
I really don't know what's going on with that test.
You're using cocaine. That's what's going on. I mean, I don't. I just don't know who you think you're fooling.
I took 2 more tests. I don't know what's going on. They didn't even give me the test results for today. She got the other one for the 30th. That's the only test that showed up right after I went to court here.
What?
After I came in on the 16th.
When I revoked your bond, that was mid-June. I just read off every test since mid-June. And virtually every test, you're positive for cocaine.
It takes a while for it to come out your system. And I have bad kids.
Okay, let's assume that's correct, and it's not. But let's assume that that's correct. Then the cold-hearted reality is that when it was supposedly out of your system on July 16th, we should have not seen cocaine again. Yet on July 21st, I have cocaine again.
But that's what I'm saying. In the other night.
I'm not putting up with it. You're gonna have to figure it all.
I have not been doing.
Absolutely, you have just decided that you want to use when you want.
What about today's test and the other tests?
What about the positive test?
I don't know how it got there.
I do want to say on behalf of Ms. Beaver, she is engaged in CCOP at community corrections, through CCOP, she is attending AA meetings as well. She did provide me with an attendance sheet. She's going multiple times a week. Her last test being twice on the 30th.
And then
Is this also a test too?
Yes.
I'm sorry, I misspoke. Her last AA meeting being the August 1st. So she is engaged in treatment and AA. I'd ask the court
Does she
consider.
have a prescription even for the opiates?
Yes, I do.
I believe she did give the prescription for the benzos and the opiates to
That's what I thought, but
community corrections.
it's not necessarily my concern. I mean, it's a cold hard reality. 1, 2, 3, 4, 5, 6, 7,
Critical system.
9. The last 9 tests, 7 have been positive for cocaine.
But that's when I first got arrested. And it takes a while to come out your system. I did jail time. I was in jail for 2 weeks.
Oh, I know. I put you.
And it was still in my system.
No, you weren't testing while you were in jail.
When I got out,
I know.
but it takes.
Showed up. Why do you think it just showed up? Because you used.
It takes. I have 2 half of kidneys. I had kidney cancer. It takes a while to come out your system.
So you want to explain how it comes out of your system and then back in your system and then
I tried to get that test done over.
And there it is, remanded into custody. Translation: she's going back to jail. The judge is even open to inpatient treatment, but only if she's ready to face reality. It's the legal equivalent of saying, we can fix this, but first you've got to admit the car's on fire.
They said it was too late to do it over. I don't understand how one test comes out and the rest is negative.
Because you're using.
Your Honor, I'd ask you to consider keeping Ms. Beaver's bond the same and having her continue to go to CCOP. In the alternative, if she is remanded to the jail, would Your Honor consider releasing her to inpatient?
I would consider release to inpatient treatment. She needs some kind of help because she can't even be truthful with herself. And at this point, bounds revoked. Defendant's remanded. We'll see you on September 3rd. I'm done.
Ms. Beavers, I think, would like to request a hearing on the test results and the bond violation.
You can have a hearing on the 3rd. It's my next available. Call the case of People versus Eduardo Benavides.
All right, so let me have this.
Ma'am, who are you?
I drove Miss Beavers here.
Yes, I'm keeping her.
May I ask for how long?
I don't know right
She
now.
have kids and stuff, and
Ma'am, I think you just heard this hearing. I get it. That's why after the first time she did this, I let her out. And she just won't stop.
well, I'm a living witness for tests saying something that I never.
Ma'am, I'm not gonna say, I'm not debating it with you. You can leave now. Thank you.
Yes, sir.
Your name, sir.
Eduardo Benavides.